Good morning to all. So today we are in block number five, and block number five we have four different acts are there. Under one of the act is Contract Labor Regulations and Abolition Act 1970, and also we are going to discuss one more act, that is Maternity Benefit Act 1961. So these two are we are going to discuss today in detail. So, in this topic, we are going to discuss the Contract Labor Regulation Abolition Act. What is the need for this act? What are the objectives of this act? Uh, when it is commencing this act, the scope and it is applicability of act, and the basic definitions of this act, and who is the advisory body in this act. Also, we discuss, and the registration process of establishment under the Employees Contract Labor Act, prohibition employment of contract labor, appointment of labors, licensing officers, and licensing contracts or appellate authorities. All are we are going to discuss in detail one by one. And also we discuss the importance of Maternity Benefit Act 1961 and the need and commencement, the definition under Maternity Benefit Act 1961 also we are going to discuss in detail. So let's start with first topic of today's is Labor's Contract Regulations Abolition Act 1970. And one more is Maternity Benefit Act. The two acts are legislature enacted by Government of India. So regulation these contract labor acts intended to prohibit the employment of contract labor in certain circumstances and to regulate the working conditions of contract labor during the employment. So same as other employees are getting same kind of benefits or privileges are same applicable to this contract labors also. So that is the reason separate act will be enacted for this contract labor to give this whatever this legislative provisions to same to the contract laborers. Right. And also the Maternity Benefit Act 1961 is also regulate to give some provisions to the women employee working in establishment or any concern a certain period before or after childbirth or and provide maternity benefits and certain other than including maternity leave, wage, bonus, and nursing break, etc. to women workers. uh, these two acts also explained in detail one by one. So let's start with our Labor Contract Regulation Act 1971. The 1970 has been enacted. It's applicable to entire whole India. This act is very intended. The object very act is to prohibit. This is the object of this act to prohibit the employment of contract laborers in any circumstances and to regulate to work conditions, the working conditions also we need to regulate of labor contract labors during an employment. So to provision, no, what we can do is the company has to giving the same equivalent prior to this if the worker is a working under Contract Labor Act or it is working in other labor is also equivalent to same to working conditions point of view. The Act attempts to provide basic facility to the employees and ensure they do enjoy certain rights which are part or equal to the benefits given to direct to employees. So they are par equal to direct employees. So this act is provides provisions to ensure that the contract labor is not misused and the right of workers employed on contract basis is also protected. So whoever is working in contract labor or equal and direct labor are both are same for this establishments as per this Act 1970. So this act does not ban contract labor altogether, but put some restrictions and to prohibit under its circumstances. So this is the object or purpose of this act. So what is the need for this act? What are the conditions for this are giving this important this act? So contract labor is a significant and growing form of employment where you can see the transportation, road construction or bridges construction. The laborers are not the direct employees of this, right? The worker, whoever this work assigned, he has appointed the laborers and he will do the work. But the where this principal owner has to provide some basic amenities and he has some follow the rules and regulations as similar to direct labor. So contract labor is significant and growing form of employment, and it is prevalent to at most all industries or establishments, all in agriculture related sectors, in service sectors also it is applicable. In general reference to workers engaged through an intermediary and is to based on its triangle relationship between enterprise, contractor, and subcontractor of these workers. So there is a triangle relationship between three, right? The owner and intermediaries and the laborer, right? So here, these workers are millions in numbers and generally beyond this. So we can find both are contract laborers in unorganized sectors, right? Of course. So these are the system works and usually on receive and more than that exploiting all this, but uh, they have to be very little bargaining power. To compare direct labors, these contract labors are not same part of bargaining power and have a little or no social security and are often engaged in hazard occupancies like chemical factories or coal mines or some chemical industries. So wherever these hazard works, the health safety is also important, but they are not giving the same on par equal to direct labor. So they are often defined this minimum wage and how to be little or more no security sum of employment. So this is the nature of works, difficulty to ensure closer supervision by the employers, and cost effectiveness and flexibility in power management, deployment, concentrate on core competence, etc. Justify the system of contract labors. All are these reasons for this act. So recognizing all this, the need for protection of interests of contract labor also the top priority identified in 1970s was brought in the uh, statute book to regulate the to employment of contract labor in certain establishments to provide for its obligation in certain circumstances and for matters concerned with so Contract Labor Act 1970 and regulations in rules are framed as per this act. Rules are framed in the year 1971 and it's forced with 10th February 1971 onwards. The constitutional validate these rules challenges before Supreme Court under Court Graman India Limited and Union of India in their 1974. The Supreme Court upheld the unconstitutional validate of this act and held there should be no under seasonable of these measures. This act were enforced again 21/3/1974 after the Supreme Court judgment. So the objectives are very clear. The objectives of this Contract Labor's Prohibition Abolition Act. So this act regulate the contract laborer in certain establishments to mitigate the plight of contract labor, to abolish of malpractices attributed to the contract labor system. So this act at abolish of contract labors wherever this possible. Mahabub, am I audible? Hello, Mahabub. Hello. Okay. So these contract labor acts wherever the possible and to regulate the conditions of contract laborer in establishment or employment wherever this abolition of contract labor system is not considered feasibility. So commencement and scope. So this is commencement of, as I told you earlier, 10th February 1971 onward, this act was enacted, and the central labor regulations are 1970 to regulate employer contract labor at certain establishments. They clearly who are this covered under, who are not covered under, right? So according to Section 1, subsection 4, as per this act, so every establishment in which 20 or more workers employed. So worker number is 20 or more. So 20 or more members are working, 20 or more workmen are employed, were employed on any day of preceding 12 months of contract. 12 months of contract. So 20 or more are 12 months of a contract labor. For every contractor who has employees or who employed on any day of the preceding 12 months or more works. So these of establishments are applicable this act. So wherever this establishment, the minimum number is 20 or more worked under contract labor. So the appropriate government, as I told you earlier, the appropriate governments are state governments or central government may, after the review, after giving the not less than 2 months of notice, 2 months of notice of it intended to do so. So without notice, we can't, yeah, the establishment can't remove this contract laborers. So they need to give 2 months prior notice by a notification given by this official gazette. Apply the provisions of this act to any establishment or any contract employing such number workmen less than 20 as may be specified in this notification. If there are 20 also, if this give this separate notification, they also considered. So applicability of this act. So this act is applicable all the establishment wherever this the contract who are working more than 20 workers, more than 20, and on any day of preceding 12 months. So this act does not apply to some of the establishments where the casual work is very casual nature. So intermittent nature, being seasonal, na, wherever the work is there, then we take, then we can remove. It's not possible. So this work is not considered as a intermediate. It was performed more than 120 days preceding last 12 months. 120 days means almost 4 months. So 4 months they need to work. Of its and seasonal character is performed more than 60 days in nature, more than 2 months. The appropriate government may give the appropriate government may giving not less than 2 months of notice by the notification in the gazette and extent to the application of this act and establishment of contract employing more than 20 days. So after this, we know this the definition of this act. So appropriate government, as per this Industrial Dispute Act, the central government at the same time in relation with other establishment, government of states which other than the establishment also situated. Wherever the state, the industry or establishment is situated, it is also appropriate government. Central government or state government as per this Industrial Dispute Act 1947. Right. So contract labor, they define as per section 2, subsection 1, subsection B. So workman shall be deemed to be employed as a contract labor in or in connection with the work of an establishment when he is hired in connection with such work by a through a contractor which are without knowledge of principal employer. So no need to give the knowledge of the employer, right? Principal employer. For example, right? Road construction. So whoever this road construction, whoever this part in the tender, so they will appoint the contract labors, right? So if this major employer, the principal employer, may not be knowledge about this, who are these contract laborers, how many are working, what is the available, but they need to mention this facilities. We'll go for next topic, that is, so contractor in relation with establishment, the contractor means a person who undertake to produce or given result of establishment. So it is intermediary between the laborer and principal employer. Other than more supply of goods or article of manufacturing or such establishment princess through a contract labor or uh, who supplies contract labor for any working day. So here also see that controlled industry defined section 2, subsection 1, subsection D. Control industry means any industry, the control of which by the union has been declared. The union has been declared by the central acts. So we will declare here the union has been declared as a central acts. So establishment, the companies, whatever the organizations or the institutions are under establishments are there. Any office of the government or local authority or any place that trade is all are covered under. So principal employer in relation to the any office or department of this act, government or local authority, head of this, head of that office, right? All are under considered this act. So in a factory, the owner or any occupier of the factories and where the person has named as a manager of the factory under Factories Act 1948, so such names. So workman is clearly mentioned here. Advisory boards. So central advisory board as well as state advisory board. The central advisory, who will decide this? The central is decided. Central advisory board applies the Contract Act registration process. The registration process. So appointment of registration officer. So as per section 6 of this act, the appropriate government may appoint by giving the notification official gazettes, person being gazetted officers of this government to be uh, redesignated officer, registering officer to define the limits where which will registered officer shall be exercise the power conferred on him by this under this act. So here the registration of certain establishment also clearly mentioned, section 7. So revocation of registration and certain cases. Sometimes that can be revocation of this act and effect on non-registration organizations. So under section 9, no principal employer of an establishment to establish. He has not obtained the certification of registration or any certification has been revoked by these organizations. So prohibition of this, some of these in establishments are not allowed the contract workers as per this act. So here what the most significant provision for the act is it employs appropriate government. So the following steps are to be have required to make taken before such notification is issued. The provision will also take part. The appropriate government shall consult this central board or as this case may be this state board. The appropriate government shall be regard to this condition to work or benefit, provide for this contract labor, the establishment of such situations, right? So appointment of licensing officers and licensing contract is also appointed as per the Act under Section 11, subsection under Section 11. So licensing of under Section 12 is clearly mentioned about licensing of a contract, uh, contractors to appoint these contract laborers. Right, for this license will be issued on the payment of the prescribed fee and on this deposit of security, if any, for the due performance of conditions prescribed in these licenses. The license fee be range between rupees 5 to 125 depending upon the number of workmen employed in the contract. The license is not transferable. So one license cannot be transferred to others as per this Act Section 12. And grant of license after verifying all these, the contract is will be license will be given, and they can appoint these laborers under this act. So revocation, suspension, and amendment of these licenses. So depending upon the licensing officer is satisfied either or any reference mode to him to on this behalf, or otherwise a license has been given this act. So here, after this, we go for if anything happen between the licensing officer, all these. So within 30 days, appropriate the aggregate maybe give this notification date will covered for the governments. So what are the welfare measures are taking part for the contract laborers on par with direct laborers? Right. The first one is as per this act, the appropriate government are giving the direction to these establishments to initiate if the number is more 100 or more, so they need to provide canteen facility for contract laborers as per this section 16. So if 100 or more than contract laborers are working in any organizations, so the principal management has to provide canteen facility for such contract laborers. So the rules may provided the date which the canteen shall be provided, the number of canteens and establishments provided. So similarly, as per section 17, subsection 1, so restroom to be provided for the contract laborers, and wherever the contract required to halt at night in connection with work or of an establishment to which this act applies. So this has to be provided, restrooms also provided. Then see that other facilities need to be appointed. Other facilities, it shall be due to every contract is a unique and working process is different. The place is different. So based on that, the employee contract labor is connection with the worker of an establishment under this act applies to like this sufficient supply of wholesome drinking water. So they need to provide sufficient drinking water for the contract labor to convenient places. So sufficient number of whatever the dates are need to for the convenience to this, right? So they need to provide washing facility as per section 18. So whatever these are also for under Industrial Disputes Acts, Factories Acts are covered. So basic first aid facility need to be provided for this contract laborers. So see that the first one is canteen, second one restroom, other facilities as well as first aid facility need to be provided for contract laborers for the principal investigator. The first aid box should be readily accessible during working hours as per section 19. So all establishment need to be maintained first aid box for in work near to working hours. So liability of this principal employer is in certain cases. In certain cases, right, see that is not direct employee, but there are some obligations of the principal employer to concern with the contract laborers as per this act. So in prescribed amenities like canteen, restroom, other facilities, and first aid box are not provided by this contractor within the prescribed time. In such amenities shall be provided by this principal employer within such time has been specified. So if the contractor is provided, okay. If the contractor is not unable to provide, but the obligation to the principal employer has to be provided according to section 20, subsection 2. All expenses incurred by this principal employer in providing with amenities may be recovered by him which are mentioned. So responsible for this payment of wages, a common complaint for against the contractor has been regarding the payment point of view, right? So payment is delayed, payment are not uh, paid up to the minimum wage act, right? The general common complaint regarding these contracts are payment are not paid in time or with direct laborers. So in this case, so as per this act, to take care of such malpractices under Section 21 of Contract Labor Regulations Abolition Act 1970, by laid down, the contractor shall pay wages in presence with this authorized representative of principal employer. So in behalf of principal employer, they need to pay. An obligation is also cast on a principal employer to nominate or representative duly authorized by him to present at the time of distribution of wages. All this authorities and their duties, powers, and procedure under this act. So here these authorities, registering officer is there, licensing officer is there, and affiliate officer, the inspector officer. So, like these are the affiliate authorities. They monitor, they regulate the how this act is implemented in the establishment. Anything violations are there, they will take care. Sometime offences by the companies, if the person committed to offend under this act in a company, so company as well as every person in charge are responsible to do this all these activities, right? So limitation of prospects also there under Section 27, prescribing the limitation of prospectus of stipulated that no court shall take recognize of an offences punishable under this act unless the competent therefore is also covered all these. So maintenance of is also mentioned this act, right? So here the liabilities for a principal employer as per section 2, subsection 1, 9, 20, 21, subsection 4 and 29. So as per this act, the principal employer has some liabilities. So the Registered Establishment Act, all the registered has to be establishment. This Act 1970, not to be employee contractor where there is no registration of the employer revoked. Right. To ensure that the contractor is licensed under this Act, the interstate migration workers and interstate migration workers regulations of employment and conditions of services is also covered under section under this act 1979 act. So interstate migrations have a separate act. So this is interstate, right? Bihar workers are they are work in Hyderabad and they are under interstate migration. So the rate applicable is 1979. So to provide canteen, restroom, other facilities, first aid boxes, if they are not provided by this contractor, so they need to. If the contract is not provided, the principal uh, employer must be provided such facilities. To provide canteen, restroom, other facilities are to be maintained. To pay wages in full or the unpaid balance due to the contractor labor employed if they are not paid by the contractor. So contract is unable to pay the wages, but principal employer has to be paid on behalf of this contractor. To maintain register and records, he contract labor employed, the nature of work performed by this contract laborer, rates of wages paid, and other prescribed particulars, and to spend prescribed return to the register all this mentioned. So here the basic penalties are there. Those are not implemented this act, and if any violations are there, so they need to be penalized. So abstracting in inspector during any inquiry, inspection, or any investigation, he promised up to these 3 months fine up to 500 rupees are mentioned in this act. So these are the basic penalties. So misdemeanors also given in this act. So after this, we'll go for this acts applicable to applicable of other laws also regarding this act. So Factories Act 1948 and the Provident Fund Provision Act 1952, ESI Act in 48, right? Now we move to one more legislation act, that is Maternity Benefit Act 1961. 1961 Maternity Benefit Act. So every woman has a right to live and dignity, right to live on dignity with avail certain benefits for this complete and healthy maintenance of herself and her child, even when she is not working, right? So this act is given the importance for women worker, the working conditions and whatever these benefits are there. What is the need for this act? So these need acts, right? No, the Convention of Protection of Motherhood, Adoption 1919 was the earliest among ILO Convention in 1929. Government of India reported that it was not possible to adopt the convention was in 1919. So due to various reasons, the bill was brought before Central Legislative Assembly by a private member in 1924, arguing the government to make it compulsory for these employers to provide maternity benefits to work the women workers. However, the bill was opposed opposed by the government on the grounds that need to such a bill was not left, and that is legislation was passed to this effect. It might have adverse repercussions of the employees. These the Royal Commission on Labor and its recommendation also stressed to this take suitable measures for maternity benefits provided to these women workers. So at least for women employed permanently or non-seasonal factories, as government of India was slow to act these recommendations. Like it will take a lot of time for debate and discussion and in these sessions days, but the government of Bombay passed a Maternity Benefit Act way back 1926. See, the state government, the government of Bombay, they passed the bill in 1926 before the Indian government. So it was followed by the central provinces like Madras, UP, Bengal, and other provinces also followed by Bombay Maternity Benefit Act. So this period of leave, the quantum of benefits and the qualifying conditions varied slightly from province to another provinces. So Bombay province to Madras provinces may be little difference. So like right with the view to reducing these disparities relating to maternity protection under different provinces and state enacted, the central government passed a separate uh, bill or act. It is Maternity Benefit Act 1961, right? To uniformity, providing uniform for all these states, right? After that, these acts, no, we have in the Constitution section Article 39, subsection E and F of this Constitution of India, provide that state shall or in particular direct its policy towards securing that the health and strength of workers, men and women, and tent age of children are not abused, and that citizens are not be forced to economic necessity to enter vocation unsituated to their wage and strength. So, like here, the constitutional provisions also favor to this labor's maternity benefit act. So, maternity benefit act aim to protect dignity of motherhood by providing full and healthy maintenance of woman and her child uh, when she is working. The Maternity Benefit Act 1961 applies to all the mines, factories, circus industry, plantation, shops, and establishment employing 10 or more persons. So here you can see the number is 10 or more person. Wherever the 10 or more person working, this Maternity Benefit Act will be applicable, right? Then after this commencement applicable, this act is also applied to the entire India, the whole India. It shall come into force. Such date may be notified by this official gazette. So applicability, as I told earlier, to every establishment being a factory, mine or plantation, including any such establishment belonging to the government and to every and wherein persons are employed for uh, exhibition of archaic all are covered under. So here these some of the definitions of this Material Benefit Act. So appropriate government mean that relation to establishment being mine or where any person employed for uh, exhibition of aquarium, acrobatic, and other performance central government and in relation to any other establishment in the state government as per section 3 subsection A. Child, the defined child include a stillborn child. So child defined including stillborn child also coming. So commissioning mother, it means biological mother who use her eggs to create an embryo implanted any other woman. So employer, so we also discussed so many times about it, employer and employee. So establishment means here as per this act, a factories or a mine or a plantation or any establishment wherein persons are employed for this exhibition of all are covered. A person or establishment is also covered under this act. So maternity benefits means the payment referred to in subsection 1, section 5 and 3H. So wages means all remuneration paid or employable in such cash to a woman if this in terms of contract of employment expression are implied where fulfillment and include this all. So this is also we covered so many previous acts regarding these wages. But in such case, cash allowances as a woman for this time being entitled to. So incentive bonus also eligible included the wages. The money valued, the money value of this concessional supply of food, grains, and other articles, but does not include this following any bonus other than this incentive bonus are not included this wages. So over time, the OT earnings also not included, and any other deductions or payment made on account of fines also not included in this Wages Act. So women means a person employed whether directly or through any agency for wages in establishments also covered on this act. So like here, of uh, employment of or work or by women prohibited during certain periods. So women are not allowed to work in certain period under this Act Section 4. So this Act, Maternity Benefit Act 1961, provides that no employer shall acknowledge employ a woman in any establishment during 6 weeks immediately following by the day of her delivery. This 1.5 month her delivery, miscarriage, or medical termination of pregnancy. It also specified that no woman shall work in an establishment during 6 weeks immediate following by the day of her delivery, miscarriage, or medical treatments of pregnancy. So 6 weeks are not allowed, right? So it may be noted that sometimes without prejudice to these provisions of Section 6, no pregnant woman shall or a request being made by her in his behalf be required by her employer to do during this period of 1 month immediately preceding the period of 6 weeks. So before the date of her expected delivery, so any work which is of an arduous nature or with involving long hours are under also not allowed. So here the rights to payment of maternity benefits under this act. So every woman shall entitle and her employer shall be liable for the payment of maternity benefit at the rate of average daily wage for the period her actual absence, that is to say, the period immediate preceding day of her delivery or actual day of her delivery and any period immediately following that day. So the woman has a right to get the wage rates, daily wage rate in this period, right? So average daily wage means average daily means to average of women wages payable to her for the days on which she has worked during the period for the 3 calendar months. For 3 calendar months immediately preceding that, the date from which shall absent herself account of maternity, minimum rate of wage uh, revised under this Act 1948 or 10 rupees, whichever is higher as per this Act. Then after this, a woman shall be entitled to maternity benefits if she has actually worked in an establishment of an employer from the, whom she claims maternity benefits a period not less than 8 days. Not less than 8 days. The last 12 months immediately preceding this date of takeover, etc. Right. So the maximum period for which the woman shall be entitled to maternity benefit shall be not more than 20 weeks. 20 weeks, of which not more than 8 weeks. The maximum is 12 weeks and the minimum is more than 8 weeks. So, like she will claim the benefits. A woman who legally adopted a child below this age of 3 months or any commissioning mother shall also be entitled maternity benefit for a period of 12 weeks from the date the child is handed over to the adopted mother, the commissioning period. This is also, she is also eligible for this benefit. So in case of where the nature of work is assigned to a woman for such manner, such nature that she may work from home, the employer may allow her to do so for availing this maternity benefit for such periods also covered. So notice of claims for the maternity benefit and payments also here we covered. So after such, any doubts, Mahabub? Mahabub, any doubts are there? Mahabub, any doubts? So payment of maternity benefit in case of death of women is also mentioned in this act under section 3 subsection 5(7) is clearly defined. So what are the benefits we'll get if this mother is death in the time of uh, delivery time. So payment of medical bonus so is also covered in this Act Maternity Benefit Act 1961. So leave for miscellaneous miscarriage. So this is also provide in case of miscarriage or medical termination of pregnancy. A woman shall or no production of such proof may be prescribed. He entitled to live with wages at the rate of maternity benefits for a period of 6 weeks immediately following by the day of her miscarriage or as the case may be her medical termination of pregnancy. So we live with wage for uh, tuberculosis operations also there, that is treatment. So work from home operations. So work from home option. So under Maternity Benefit Act has also introduced enabling provisions to relate to work from home for women, which may be exercised after the expiry of 26 weeks leave period. So depending upon the nature of the work, women employees may be able to avail this benefit on terms that are mutually agreed with the employer. So nursing break is also provided. So then crutch break is also provided for this act. Sir, then for feature of maternity benefit, so if anything establishment or she can be permitted to do her absent herself the provision also benefit. So like there are given this importance for maternity benefit for safeguard of motherhood. So then appointed all these authorities are there as per this act. So all the establishment are to be implemented. So there are some amendments also there. All are there. Then we have a last block in our syllabus, labor laws. So under this, we have a child labor, Child Labor Provision Act, Child Labor Provision and Regulation Act 1986, and that is block under block number 4, unit number 16. Then we have a one more unit, sexual harassment of women at workplace under Prevention, Prohibition and Redressal Act 2013. It is not Nirbhaya Act, it is indict, it is called a Nirbhaya Act. And we have a one more act, that is IT Act, Information Technology Act 2000. So these three units are covered under block number 5. So under this part, we're going to discuss tomorrow. And if you have any doubt, please. How about any others? We have only 1 minute or left. Mahabub, any doubts? Or shall I wind up? Mahabub, shall I wind up or any doubts? Mahabub, any doubts? Okay. So next class